Hello and welcome to How to Write a Tax Efficient Will with me, Deborah Powers. Today we shall be drafting a will in real time because lots of people would like to have a free will. And the topic for tonight is write a will in real time. So tonight we shall be doing our best to write a will, but this will only apply to persons who are single with adult children or married with adult children. So you are welcome to join me on another occasion if this will doesn't apply to you. Alternatively, you can contact me so that I can assist you with your specific needs. Before we proceed any further, let me introduce myself. My name is Deborah Powers. I am a STEP certified advanced will writer. I'm also a solicitor of England and Wales. I am a GDPR practitioner, and I'm also the author of How to Write a Tax Efficient Will, which you can see here on screen. In addition to that, I am also the creator of a course, How to Write a Tax Efficient Will, which allows anyone to take their time to go at their own pace and to write their own will. It also enables them to determine whether or not their will is tax efficient as they go through the process. You can do it at your own pace. The course is being offered at $97 at Deborah Powers Mastermind /Masterminds 36966. But it is on a discount at the moment. It's on 50% discount, and you can secure it for £48.50. Before we proceed any further, I need to make a disclaimer here. You can't consider anything that I'm telling you today as financial advice, investment advice, or even legal advice, because will writing is not a regulated activity by the Law Society. All I can assure you is that I am giving you the best information that is available to the best of my knowledge and understanding, and it is up to you to make some further inquiries if you wish to take this advice. So if you take the advice, you'll be doing so at your own risk. Now, the first thing we will want to do when we are writing our will, to just be a little fancy and indicate what your cover page might look like. So this is what you could have your cover page as: last will and testament of, and you put your name. Now, when we have finished this course, even though you're doing the rough guide tonight, you can continue later and type it up for yourself, and you can, having typed it up, you can then design it in the way that you feel works best for you. So tonight, I'm inviting you to consider having a cover page for your will, as you will be probably working on it after in your own time. As I said, we are focusing on people who have adult children, who are single or married with adult children when drafting this will. Now, to begin with, we can start with firstly introducing ourselves, because you have your cover page, but you now need to introduce yourself in the will. For example, say who you are. And how do we do that? We do that by using the words I, state your full name, state your date of birth, of your home address, put your address, revoke all earlier wills and codicils, and declare this to be my last will and testament. This way, if you have made any previous will, then you would have an opportunity to revoke it and notify the world that this one which you are making now is your last will and testament. So this is how we start. Again, I, full name, date of birth, of your home address, revoke all earlier wills and codicils, and declare this to be my last will and testament. So you can take some time now and use those words to begin writing your will. Now that you have finished introducing yourself, we shall now think about appointing your executors and trustees. Remember that your executors are the people who go out of their way to find everything that pertains to you, both your assets and your liabilities, and they ensure that they know where they are, what they are, and they gather all your assets and your liabilities together so that they can be assessed, so that your net worth can be ascertained. Once that has happened, your trustees are the persons in whom your assets are vested at the end of your probate period, so that they can do what needs to be done on your behalf and follow your wishes. So here in this section, it is important that you appoint persons who are accountable, who are responsible, and you don't appoint procrastinators, people who appoint persons who take their responsibilities seriously. The executors and the trustees can be the same people, so don't think too hard and long about appointing different people. You can appoint the same people as the executors and as the trustees. You can choose up to 4 persons to be your executors and trustees. In order to have executors and trustees, you will need to know their name, preferably their date of birth as well, and their address. You need to ensure that they are 18 years or over, so that they are recognized legally as adults, so that they can work, do what is required for you or on your behalf. So we need their names, their date of birth, their address, and their relationship to you. So on the next slide, we shall see some of the wording which you can use in relation to appointing your executors. At this point, we shall also begin to number our paragraphs. So your first paragraph is paragraph 1. I appoint my, do you want it to be your wife? Do you want it to be your partner? Do you want it to be your son or daughter? You state who that person is that you're appointing as is that person going to be a sole executor, or are you appointing several executors? And if he or she or any of them is unwilling or unable to act, or dies before proving my will, I appoint, remember, the name, the date of birth, the address, and the relationship to you as my executor or executors. So it depends on whether or not you're appointing one person or several persons. You will use the appropriate words. And in this paragraph, you can see that I have also made provision in case the person you've appointed in the first instance passes before you. So if that person passes before you, there is a backup. It's always good to put people in a backup position so that your will can be future-proofed. So take a moment now and consider using those words which are here and in paragraph 1. I appoint my wife, partner, son, daughter, whichever one you wish to appoint. Remember, you must put their name, their date of birth, their address, and their relationship to you as my sole executor or executors. And if he or she dies before proving my will, I appoint, again, the name, the date of birth, address, and relationship to you as my executors. So take a moment now, and this is going to be your first paragraph, and you number it number 1. Now that you have finished appointing your executors, we shall now look at appointing your trustees. That's going to be paragraphs 2 and 3. So as we are in this lesson, we are going to be appointing the same persons who are our executors as our trustees. So you will say here, I appoint as my trustees those of my executors who obtain probate of this my will. Again, I appoint as my trustees those of my executors who obtain probate of this my will. So it makes it easy. So you know that whoever was the executor and went through the probate is also going to be the trustee. So that would be your second paragraph. We shall now move on to paragraph 3. In this paragraph, you're going to give an explanation as to what you mean in terms of your trustees. In this will, the term trustee means those of my executors who obtain probate of my will and the trustees for the time being of any trust arising under this will. So you're explaining here that your trustees you're going to be your executors, as well as if it should happen that a trust arises for any reason under your will, they are also going to be the same people who will be appointed. So I will just read that again. Number 3, in this will, the term trustees means those of my executors who obtain probate of my will and the trustees for the time being of any trust arising under this will. So take a moment and you can copy these words as well. We shall now move on. Now, when you have trustees, you've got to give them powers. The powers determine what they can and cannot do. And a very quick and easy and efficient way to do that is by inserting the standard provisions into your will. So at paragraph 4, we shall simply do so by stating the standard provisions of the Society of Trust and Estate Practitioners, 2nd edition, shall apply to this will and any trust created under it. Okay, so by stating that, you have given your trustees structure, you have given them powers, and you have given them guidance as to how to exercise their powers. The standard provisions of the Society of Trust and Estate Practitioners is a document which is available online. It is currently in its 2nd edition, and it's very easy to access if they need any guidance as to whether or not they have this power or that power. They can simply download it. It's available online. So if you put that statement in your will, they know exactly what document they can use to guide them as to what the powers are. So that will be your paragraph 4. So I'll give you a few minutes to copy this statement as well. This statement here, the step standard provisions. At number 5, the next thing we shall do now is start giving directions, because we've introduced ourselves, we've appointed our executors, we've appointed our trustees, and we have given our trustees powers and guidance. Now we shall give directions as to what we would like done. So at number 5, we shall say, I direct that all my just debts and funeral expenses be paid as soon as reasonably practicable after my death. I direct that all my just debts and funeral expenses be paid as soon as reasonably practicable after my death. Because we know that we have got to arrive at what your net worth is, and the only way to achieve that is by taking all your assets and subtracting the liabilities from the assets. And if you've got any debts, also your funeral expenses, they should be deducted from your assets. So I will give you a few minutes to write this 5th paragraph. I direct that all my just debts and funeral expenses be paid as soon as reasonably practicable after my death. Now, this is time to speak about the part that's not so nice, but we need to deal with it. You need to decide whether or not you wish to be buried or cremated, or there may be some other options that you would wish to consider. And at this stage, whatever decision you've made, that's what we're going to deal with next. So think about it for a moment. Would you like to be buried or cremated? Because now we are giving directions to our executors and trustees. On this occasion, number 6, I have written, I wish to be buried, and I've put in brackets or cremated. So you can decide which one you want. I wish to be buried, or you can write, I wish to be cremated. Now, it doesn't take very long to write this sentence, which is going to be your sentence at number 6, based on your personal decision. I wish to be buried, full stop. I wish to be cremated, full stop, whichever one you choose. Another important thing which lots of people forget is that if you wish to keep all your organs, it's important that you register, and you register a decision not to donate your organs. And this can be done on the organdonation.nhs.uk. It's a register your decision, do not donate. So it's important that you do that, because the law has changed recently, and they assume that if you have not registered a decision not to donate, that you have decided to donate. So if you do not wish to have any of your organs taken away, you need to go online from now and register a decision not to donate any of your organs. Now we can move on from this. We shall do with what is called the residue. The residue of your estate. What exactly is the residue when you see that in a will? It is everything that is left over, which is yours, but which you have not allocated. So for example, you may have said in your will, I wish to give £10,000 to John, Jacob, Henry, my friend, so you have given different things. I wish to give my house to a certain person, or I wish to give the car to a certain person, or a certain painting. But there may be things in your estate that you have not allocated to anyone. So all what is left is called the residue. And it's always important to have a clause for residue, because you never know what you have not catered for. So at number 7, we shall say, I give all of my estate to my trustees to hold my estate on trust for sale, with power to postpone sale. So this takes care of anything you have not distributed in your will. So your trustees will hold it on trust for sale with powers to postpone that sale. We now move on to clause number 8. You're giving your directions to your trustees as to what they should do with your residue. And you say, my trustees shall hold the residue of my estate for those of my children who survive me and attain the age of 18 years in equal shares. Now, in some cases, people do not want their children to inherit at 18. They think they are not mature enough, and that's true in many cases. So it's advisable, if you don't want your child to inherit at 18 when the law allows them to inherit, that you change that age. So you will put a different age, 25 years. So in this case, you can put either 18 or you can change that to 25 or an age that suits you. So now you're asking your trustees to hold the residue of your estate for those of your children who survive you and attain the age of 18 or 25, whichever you prefer, in equal shares. I shall give you a minute to write these words down so that you can include it in your will. Now, here is something that is absolutely important. If you do not wish for your children to inherit at age 18, you must include this clause in your will. So anyone who has given an age above 18 for their child to inherit, they must include this clause in their will, which is going to be number 9. If you've allowed the kids to inherit at 18, you don't need number 9. But if you've used a clause which is above 18, an age above 18, you need clause number 9. Section 31 of the Trustees Act 1925 shall not apply to these trusts. What that says in effect is that the right which the law gives to the child to inherit at 18 is not going to apply here. So your trustees are exempt from that law because you have put an age which is over 18. So you want that law not to apply. The law which allows them to inherit at 18 is not going to apply. So if you've placed an age in your will that you want the kids to inherit, which is above 18 years of age, you need to put in this clause. I shall give you 2 minutes to put that clause in if you have put in an age which is above 25 years of age. Not above 25, I beg your pardon, above 18 years of age, because the law allows them to inherit at age 18. So we can move on from now. So what if a child does not survive you? I know these are unpleasant thoughts, you don't want to think about them, but there are things that we need to consider, the what if circumstances. So because of this, I have inserted clause number 10 because we need to think about these things. If any of my children do not attain the age of 18 years or whatever age you put before, 25, whichever you have preferred, then his or her children who survive him or her and attain the age of 18 or 25 years shall take in equal shares per sterpies the share which he or she would otherwise have taken. Now, I know this sounds like a mouthful, but I will just explain it in simple terms. If your child passes before you and leaves a child, you want that child to inherit because that's your grandchild. And what we have said here is that that child will inherit at age 18. So if you wanted your child to inherit at age 18, let the grandchildren inherit at the same age. If you wanted your child to inherit at age 25, let your grandchildren inherit at the same age 25. And they will take in equal shares, and persterpes means that if they also leave children, their children will also inherit. It goes down the line, the bloodline. Okay, so I will give you a moment to take down this clause for in circumstances where a child does not survive the parent, but there is a child left behind. So your child has passed and left children behind, that grandchild is going to inherit. Okay, I hope you've gotten that down. Now, we also need to cater for the unthinkable when we're writing our will. And catering for the unthinkable means that what if your entire family is wiped out? What's going to happen? What's going to happen to your assets? So in clause 11, I have included this clause here: should my children and I all pass in the same incident, leaving no issue, so there are no grandchildren, you've all been met unfortunate ends, I devise and bequeath the residue of my estate to the Dogs Trust or any charity that you intend to or would like to give it to. And people usually put a charity in there because charities, they go on and they benefit society. So you can put a charity of your choice there. I've chosen the Dogs Trust. But one thing you should always do before you choose a charity is that you should check on the Charities Commission's website to be sure that it is a registered charity in the UK and that you get the charity number so that you can put all the information in there. So charities, gifts to charities are usually used, even though they failed, even though the Dogs Trust doesn't exist anymore, the gift may be allocated to a similar kind of charity or organization that looks after dogs. So they are less likely to fail. But this is a clause for the unthinkable, what we hope will never, ever happen. So I will give you a chance to write that, and it kind of takes into account all the possibilities. We have gone through what you would like how you'd like your assets divided equally between your children. Then if your children pass before you and they have any children, it will go to that child or children, that's the grandchild. And in the unlikely event that you should all pass in the same incident, there's no one left, it will then go to a charity. So if you've written that down, we can move on to the next. Now, this is called attestation, and this is the crux of ensuring that your will is valid. This must be done properly. So you would write, as witnesseth my hand this, whatever day you are writing the will, this day of whatever month, 2022, and you will sign. But you must do that signing in the presence of two witnesses. So I will just give you a moment to copy the wording, because that's what I'm focusing on here right now, the wording that you need, as witnesseth my hand, because you are attesting that you know what you're doing. Your hand is going to give effect, your signature, is going to give effect to this document. I shall give you a few minutes to write it down as witnesseth my hand, or witness my hand, this, the date. And then you don't sign now, just leave that section empty until we have the right people in place for you to sign. So another thing you need to write down to ensure that you have the right wording is, as part of this attestation, is signed by the testator in our presence and attested by us in the presence of the testator and of each other, because you need 2 witnesses to see you sign and then sign in your presence. So they must be there with you, see you sign, and sign in your presence. It does not mean that they need to read your document. No. They can say, I'm writing my will, I need you to witness me signing, and they sign saying that they have seen you sign. So this is the wording to use. I will give you a few minutes to write that down so that you can design your will in this format. Okay, so now the signing instructions. As I have been reiterating throughout this, it's so important because this is what's going to determine if the will is valid or not. So the signing instructions are, you must sign in the presence of 2 witnesses who are not your beneficiaries, not the people that you have named in the will that you want to give the property to. No, neither should they be the partner of your beneficiary. So if you're giving the things to your daughter, don't ask her husband to sign the will that he has as a witness. It's not a good idea. So the witnesses must be present at the same time, and they must see you sign and sign as witnesses in your presence. If your will has many pages, it is advisable for you and the witnesses to endorse each page of the will. So you and the witnesses will endorse each page as well. But this attestation part needs the signature and the attestation of all of the witnesses. You sign and then they see you sign, as we have seen here. So you sign here and then they sign that they have seen you sign. And so once you've followed all these instructions, your will should be absolutely valid. Now, don't panic if you haven't gotten all the instructions as we went along. I saw that some people joined a bit late, but this is being recorded and it will be available online. I'll also send it to everyone again to whom I sent the invitation, and it will be on my YouTube channel as well. Also, if you would like to take your time and have all the information, even much more information than I've shared here tonight, you can go and purchase my mastermind course, How to Write a Tax Efficient Will, where I go through your tax position with you, the things you need to look out for. I also take my time and go through the will writing with you. And I also give you sample wills so that you can be helped along to achieve a tax efficient will. There is no rush. You can do it at your own pace, and you will have access for life as long as the course is available. And you will also be able to do it at your own pace. You know, there's no rush, no hurry. The course is currently on a 50% discount. So it's on Mastermind. Just copy that information here, put it in your browser, and it will take you to the course. Alternatively, if you would like to consider purchasing the book instead. The book has all the information as well. It also has lots of draft wills. It's only $14.99 and it's available on Amazon. If also you are thinking that you need my assistance, I am available. You can send me an email on deborahbowerswillwriting@gmail.com, as we see here, and make an appointment with me for me to assist you with your will. You can also give me a call. My number is 079-818-10322. So I hope you've enjoyed tonight's session. I'm sure that many of you will find it very useful. At least it will help you understand the structure and the things that you need to think through as you consider writing your will. Are there any questions? I'm opening the floor now to anyone who wishes to ask me any questions. Okay, there are no questions. I'd like to thank you all for attending tonight. I really appreciate it. The webinar will be on my YouTube channel, and I will also send it to everyone else through their phones. So thank you ever so much for attending. Remember, you can get the course to help you along at your own pace. You can get the book as well, and you have access to me. You can call me and we can discuss how I can assist you with writing your will. So do have a great evening, everyone, and all the best for tomorrow. Bye-bye.